Two and one. We are live.
Well, look
Good
at that.
evening. Sorry, what's that? What'd you say? You
That's it,
caught
we're
me.
live.
You
I know,
caught
we're
me
live.
as I was
That's
about to
good.
just start, and like
It's your bit. You talk. You talk.
you just cut the intro like just straight down the middle. Right. Good evening. Welcome to another live episode on Disqualified Dads. I just want to point out, guys, since we started doing these live streams, these Q&As, this is episode 52. This is episode 52 of the live streams Q&A on Disqualified Dads. So welcome to the show. Now, just want to remind any newcomers to the purpose of the stream. This weekly stream is there to help aid you and support you through your family court journey. We provide technical, emotional, mental support, helping you get closer to your kids week by week and help you through the meat grinder that is the family court system. Now, also, yes, I am joined by my co-host. You may all have seen him on TikTok, Instagram, on YouTube. He's flooding the internet with shorts every single day and night. He's known as that family law guy, also Mr. Ryan. To some of you as Mr. Ryan, to some of you as Dan the Man, and on the internet, on social media, he is known as that family law guy. Mr. Ryan, welcome again to episode 52. It's an absolute pleasure to have you here and to be joined by you and to be working with you and to present these episodes with you. When you're not here, I sort of feel a little bit lost. I feel like an orphan when that one day you weren't here, that one evening you weren't here. At that point, I realized that evening I felt like an orphan. I felt like Billy No Mates. I thought, how do I do this on my own? I've got accustomed to having a wingman. You know, it's good to have a partner in crime. In this case, it's you, Mr. Ryan. So over to you, Mr. Ryan.
Good evening. Good evening. Good evening. Welcome to Sunday and welcome to is it episode 52? Goodness me. Yes. That's alarming. Well, I look forward to episode 100 then. Which will be, when would that be? Where are we now? End of June. So
like
that'll be
no.
How can it be by December?
No, sorry, next July.
Yes, next year. Yeah. Right. Okay. All right. Well, that's good. I like 52 episodes. Good start. Okay. Well, it's been it's been yet another week out there in family land. We titled this episode two-tier justice, and what we're going to do just for the next few minutes, I'm just going to talk about that, just to explore why it is that is a concern of mine, why it is that has sort of come to the front of my mind this week, because the whole issue of two-tier has been very, very prevalent in the news this week, predominantly around the benefit reforms and the alleged U-turn on the part of Keir Starmer and the Labour Party in terms of what they're going to do with the benefit reform bill when it gets voted on later this week. But so there's a suggestion that we're about to have, if it goes through, a two-tier benefits system where people with the same set of circumstances could end up actually getting two separate payments in terms of their benefits. And that strikes me as pretty unfair. But over and above that, it led me into thinking about the justice system, because obviously I spend all my working life these days, in the justice system. And I've been conscious for years about the fact that it's not fair. I've been conscious for years that the adage that he who has money can buy the law is very true. I mean, particularly in family court, and that gives me something of an issue, because the theory is justice is available to all. You know, the reason that the statue of Lady Justice, she stands with a sword in one hand and she stands with scales in the other hand, and she stands with a blindfold on. The reason that she wears the blindfold is in order that she is blind to inequity, and so everybody gets a fair crack of the whip. That is justice. It's arguable whether that happens in the criminal system, but we're not concerning ourselves with that. We're going to just focus on what happens in my experience in the family system. And I would put it out there, and here's me being a bit contentious, but I would put it out there that we currently have, and we have always had, a two-tier justice system in the family law courts. My view is he who has, or she who has, funded legal representation will always be in a better position than he or she who attempts to go through the court either alone or with a Mackenzie friend. Even the finest Mackenzie friend in the world, whoever that may be, is still not on a par, in my view, with having paid or funded legal representation. So there's issue number one, and that's quite worrying, because the court bases itself on a series of acts, two primarily acts of law. One is the Family Law Act, 1996. One is the Children's Act, 1989. Both of those acts say that everybody who walks into court is entitled to be dealt with on an equal footing. That the court will not favour one side or the other, regardless of their circumstances. I'm sorry, but that's just not the case.
Okay, look, so I understand it right, yeah. So I'm trying to understand this. So when you say in family court, because I was always I was sort of under the impression that family court. Let's obviously stick to family court. The family court was. I actually heard another Mackenzie YouTuber say this, that the way family court is and laid out and works is so that money doesn't play a big part, because children are involved. So they try and keep the children at the focus of how it runs. Because the bottom line is, if one party has more money than the other, they can get a favorable outcome. Hence, that's why it's designed to not favor finances or those who have representation. Again, that was, I think, and I heard this categorically by another Mackenzie YouTuber. So that was the first fantasy or the line that just stuck in my head. But obviously we know that's incorrect. Secondly, we know this lived experience of, if someone has a fully funded legal team, whether by just having wealth or legal aid, compared to the other party who doesn't have a full legal team, is automatically at a disadvantage. I mean, that now screams out obvious common sense. Now, in my mind, again, the way I see it is, let's say for argument's sake, the opposite side have got that fully funded legal aid team, yeah? It's on legal aid. But let's say I was a well-to-do character. I had a surplus amount to lawyers, barristers, top of the line. Money's no object. Would you say that could favor me, knowing what the law is like, knowing how the resident parent holds all the cards, regardless of how powerful you could be? Do you see what I'm saying? So I always felt money is a tool that you can use against the system. It's a leverage. That's all it is. But will it really give me a favorable outcome if I've got more money than the opposition, say, for argument's sake?
Okay, all right. Well, there's two questions there, isn't there? I mean, there's question number one. If I've got more money than the other side and I'm the good guy, how am I going to fare? And if I've got more money than the other side and I'm the bad guy, how am I going to fare? So let's answer the two questions. If you're the good guy, if you're the one, be it the mother or the father, who is in family court, and you have got the court on your side, because you're not firing you're firing your allegations across the room at the other side, who are undoubtedly going to get found out to be a terrible human being. If you walk in heavily armed in terms of your legal representation, just prepare yourself for the victory parade. Book the open bus to drive down the street with your trophy, because you are going to win, hands down, without a shadow of a doubt. It doesn't matter what happens or how long it takes, you are going to win in family court. So that's an easy one. Let's tackle the more challenging one. If you're the bad guy and you turn up in family court with decent decent representation, you turn up with barristers, you show up with a good crew, it immediately levels the playing field.
Right.
Because your crew, your legal crew, will talk down huge amounts of the allegations on your behalf. I have been in family proceedings where the bad guy, doesn't matter whether it was mum or dad, whether the bad guy turned up with a very, very, very capable barrister. And by the end of the hearing, I was convinced that the bad guy was going to leave the room levitating. He was such a beautiful human being, given the opinion that had been offered by this barrister and accepted by this court. So, yeah, if you've got the money to spend, then you can build on your positive position, or you can you can mitigate some of your poor position if you have got the money to spend. And that in itself illustrates to me that we have got a two-tier justice system, because we're essentially saying if you've got the money, be that money privately funded or via legal aid, and that's obviously a whole separate conversation about how do I get legal aid, then you are in the pound seats. You are certainly holding the trump cards when we walk into that courtroom. The guy or the lady or the girl or the human being who goes in possibly with a lesser capable barrister because they can't afford a top of the range barrister, they can't afford Cristiano Ronaldo, or they've just got in with a solicitor because they can't afford a barrister, or they've just got in with a Mackenzie friend. You are on the back foot. You are on the back foot, and regardless of the circumstances.
Okay, so let me throw a little curveball at you then, yeah? So regardless of either or position financially, let's say, forget the financial position of either party for 1 second, yeah? Does the fact that whoever is still the RP, the resident parent, they hold the trump card still, really, ultimately?
If
you're the RP, beyond the money, surely money is a tool that can help you leverage certain things within the case and maneuver, yeah? But the trump card still has to be the RP. If you are the resident parent,
I agree with that. I agree with that. He or she who holds the children is still in the control, still in control of the dynamic. But if the other side turns in, if the non-resident parent turns in with a decent crew, they stand a decent chance of moving the dynamic of the courtroom. Yeah, moving the needle. Yeah, let's use your analogy. Yeah, they stand a good chance of moving that needle with a decent crew. Because the problem you have, and I've been in too many hearings that are like this, that the judge will start with the most senior legal in the room. So if it's a barrister on one side and a solicitor on the other, the judge will always start with the barrister. Always.
Yes, of course, yes.
What the barrister will then do, because this is what all barristers are trained to do, and well done them, is they will filibust. Those of us who don't know what filibusting is a skill that's usually used in Parliament, where if somebody else is waiting to speak in Parliament, they have to wait until the previous politician has finished speaking, and they can't interrupt. So what the first politician will do is they will filibust, which means they will just talk and talk and talk and talk and talk until the allocated time has gone and there's no opportunity for the second politician to step in. This happens in court. A decent barrister will stand up, and I had an example very, very recently. A decent barrister will stand up and they will filibust. They will talk and talk and talk and talk and talk and talk just to run the clock down. And your opportunity to defend your position or fight your position or challenge your position is ebbing away with that clock.
Yeah, so basically, the way I would conclude this is money is just another weapon that you can use if you have it at your disposal, just to try. It doesn't matter which side of the fence you're on, but it will help. It's just another tool in the box that can help even out some of the odds either for you or that are against you. Simple, which makes perfect sense. I just want to touch on something that someone sent me this week, a screenshot. So he's a regular listener. I'll mention no names because I'm paranoid about mentioning people's names because some
Mm.
people have used their real name. So I first thing I want to say is if you are concerned about being found out or you're concerned about being on here or this being brought up in court against you, please use a different name. I try not to mention anyone's name. I refer to people as Mr. H or Mr. S or Mr. Amp or whatever. So do not put your real name on. If you dial in and you come on live, leave your camera off, just leave your audio on and use a different name, please. Use a fake name so you cannot be pinpointed. Now, earlier in the week, I spoke to a chap who listens pretty regularly, said a friend of his has been sentenced 1 week in prison by a family court for going onto a podcast and speaking about his case. Now, he didn't mention the name of his ex or his children, but he's saying his friend has been sentenced to 1 week in prison. Now, like I said, I believe this is probably the most extreme thing I've heard about in family court. I've heard of people going to prison, but for a podcast, for going on social media, like I said, it's quite extreme. So let's see how this pans out. Let's see if this actually materializes. But that's what I've heard. What do you think of that, Mr. Ryan?
I mean, you obviously mentioned this to me before we went live, and if it's true, you know, if this information is true, that the family court has sent somebody, you know, has incarcerated somebody on the premise of them exercising their freedom of speech, that worries me considerably about where are we in this country. However, having said that, we obviously don't know the detail. If the individual, whoever this individual was, went onto a podcast and started slating the other side and made it, and the detail he provided made it very obvious who the other side was, then more fool him is probably the comment I would make there. Because you do need to be careful. I mean, I you know, you and I both guest on podcasts, and we do this. You know, we do this, and on here, you know, I speak quite openly about my experiences in family court and about the things that I see, and the things that I like and the things that I don't like, and I do criticize sizable elements of the family court. But I'm always careful because I need to be. I'm always careful not to reveal names, not to reveal details, not to make it so specific that somebody out there could be listening and very clearly decide what it is I'm talking about. And the other thing I'd say, and you know, we touch on this from time to time, and I'll touch on it now. The conversations that we have on this live stream, just like the conversations that you and I have as guests on podcasts, are our opinions. They are our views of what is going on out there, and they're not specific to any particular case. They're not specific to any particular set of individuals. From my point of view, when I talk about what happens in family court, it is a global coming together of my experiences to say, look, I've seen stuff, I've experienced stuff. Some of it I like, some of it I don't like. But going back to the original point, if there is somebody out there who has had to spend 5-7 days incarcerated, having appeared on a podcast, without knowing the detail, without knowing any more details than we already know, that concerns me greatly.
Yeah, I think we need to wait for the detail because he must have gone on there. You may not have mentioned names, but he must have gone all that. Because look, I've been on a lot of podcasts. I've lost count of how many podcasts I've been on. And I mean, now I can talk about it because I don't actually have a running case in family court. So I could probably talk about it openly now, yeah? But I've been on many podcasts, even in theory, whilst I did have a running case, and touch wood, no comebacks. So I think he must have been quite blunt and straight, just didn't mention names. So you know, because like I said, there's a way of doing it. And I think I've navigated it pretty well, you know, considering I've been doing this for a while now. So yeah, we'll wait for the details on that. We'll wait for the details to come out on that. Right, Mr. Ryan, these questions are mounting.
Let's have a look at a few then. Come on then, let's
come
on then. Let's just dive in.
Right, Mr. H, Hungry Hippo. I'm sure that's not his real name, so we're good here. I'm sure no one can pinpoint who Hungry Hippo is.
It might be though, mightn't it? You know, I mean, you know, I'd love if it was.
Right, Hungry Hippo. Hi guys, how many questions am I allowed to ask Kafkas at the final hearing, please? It doesn't say on court order. Cheers, guys. Thanks for the continued support and help. I love that. Thank you. That's why we're here. Straightforward.
Yes. Right. Very short answer. Very simple question. There is no limits to how many questions you can ask CAFCAS. You ask the number of questions that you believe are proportionate in order to achieve what it is you're trying to achieve. If the court, or more likely the judge or magistrates, don't like the theme of your questioning, they'll stop you. But there is no formal limit as to the number of questions that you can ask CAFCAS. If you want a guide, if somebody says to me, you're going to be, if I'm going to be questioning CAFCAS, how many questions am I going to ask? It's rare that I go beyond 20 or 30 questions over the course of about 45, 50 minutes, because by that time, I've got what I wanted from them in terms of the information I want them to share. Beyond that, I think you're on a bit of a fishing trip. But that's the answer.
Yeah, simple. It depends on what you're trying to achieve and what information you're trying to get out of them. So don't ask questions for the sake of asking. Ask them strategically for what you're trying to get out. Simple. Right, let's move along. Let's fly through. Mr. A, question or comment is one of two. Evening, gents. Mother has not submitted police disclosure or allegations required in June. We're in July now, so she hasn't required in June. She's blaming the loss of her mother, but has had over a month. She requested a 1 month extension. What will likely happen in the next hearing a month away with no police report or allegations submitted? Also, social services have had to do a Section 37 report. All right, this is a good question. This is something that could happen.
Yeah, there can be delays. Obviously, there are often delays in family court, and so if somebody has a set of circumstances, and let's give this lady the benefit of the doubt. If she has lost her parent, lost her mother, then I have a sympathy for that. So things happen in real life outside of the fight in court. Things happen, providing that she has provided that information to the court, provided she's been honest and open in her wish. I'm sure the court will allow an extension. It's very likely, given that you're very unlikely to get a police disclosure in time for your next hearing. So it's very likely that when the court become aware of it, they are likely to adjourn your hearing and move it to a later date in order to wait for the information to arrive. Because otherwise the hearing is going to be ineffective and a complete waste of court's time.
So basically, by the looks of it, you might have a delay by another 3 months. Potentially.
Possibly, yeah, possibly.
All right, sorry, man. Sorry, Mr. A. Just not great news, I understand. Right, Mr. J. Evening, chaps. Right, this is a good question. Mr. Ryan, how do you advise your clients to deal with post-contact anxiety? I'm always worried mum is going to make new allegations off the back of contact weekends with our daughter. Okay, this is a good question. How would you tackle this?
It's an ongoing issue, isn't it? It's an ongoing issue that every parent who has contact, be that contact centre or Saturday afternoons with their children or whatever, every parent who is the non-resident and has contact has this worry that immediately following contact, all of a sudden they're either going to have social services knocking on the door or the police knocking on the door or CAFCAS ringing them up to say, oh, what happened this weekend? The children came home distressed. The children were beside themselves. And the thing to do, unfortunately, up to a point, the answer is you've got to live with it. But the thing to do is, as long as you are comfortable that the contact that has taken place, that the time you have spent with your children has been healthy, wholesome, and damn good fun, you have achieved your objective. So the question of how do you deal with post-contact anxiety is you've got to put, and this is I'm about to lead into Farouk's world and away from mine, but you've got to put some positive spin on it. You've got to engage your positive energy, and I'm going to pass over to Farouk in a minute. You've got to engage your positive energy and not worry about the fact that this is going to come, because the reality is it probably is going to come. So you're going to be quite blasé about it. And when CAFCAS rings, say, yeah, was waiting for your call. Knew she or he would complain. Knew there was something I would do that wasn't going to suit them. Knew they were going to say that the children were distressed and hysterical when they came home. If you are in a contact centre, it's very difficult to capture, and I'll use that word. Work that out as best you can. It's very difficult to capture evidence of the contact between you and your children. Obviously, if you're seeing your children out and about, in the park or in the shopping centre or whatever it might be, it's a little easier to capture moments of the contact, be that a little short video of the children having a good time with you, or some photographs or whatever. But if you've got the opportunity to just build a little bit of evidence that just says, look, here's what contact looked like. This is my little lad running around like a lunatic, chasing a ball and wearing me out. That's what contact looks like. So try not to focus on, because if you're focusing on the post-anxiety, what you're not doing is focusing on what's happening in the contact, because you're already fretting about the aftermath. Over to you, Farooq.
Yeah, what I'll say is, look, number one, right? Yeah. Energy flows where attention goes. Negativity is a self-fulfilling prophecy. We think something bad's going to happen. You think, I knew it happened. It's because you were manifesting it. You were thinking it. You were visualizing it. So my point is, just focus on your kids. Focus on having a good time. Number two, I've always said again, if the kids are, say, in your house, as contacts in your home, yeah, the amount of devices you can get just to be recording inside house. And look, take plenty of photos and videos, I would, of you playing with your kids and just doing your normal stuff, having a good time. Plenty of photos and videos. And if you have a general device, like a Ringo type device for inside the house in the sort of common areas like living room where mostly you're going to play, just have that recording anyway. So if something does come out, you're already covered. Like I said, you don't bring it out. You never tell anyone. It's just there as insurance. So you've got the insurance in place. Now you know your insurance is in place. You can just let go and relax because no one can do nothing. No one can say nothing. You've got the evidence if it comes to it. And focus on your kids. The anxiety is for a situation that hasn't happened yet. What I'll say is wait till she makes the allegations and then deal with it. Cross that bridge when it comes to it. But until then, I wouldn't even worry about it. I wouldn't even think about it. The fact that you've got contact, you should be celebrating. You should be over the moon, jumping with excitement, with a smile, driving to pick them up when they come running up to you saying, Daddy, 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 and you're going to swing them in the air and put them in the car. That's what you should be focusing on. So that's what you need to think of now. The anxiety is you're worried about a situation that hasn't happened. How can you worry about something that's not materialized? So simple. I would say focus on the kids, focus on having a good time. Yeah. Energy flows where attention goes. And I want you to think about what you're going to do in detail, the things you're going to say to your kids, the type of game. I want you to spend time thinking about this, the positive stuff and the constructive things that you're going to do. And like I said, with all of this in life, the rule in life is this. Other than what goes on in here, you have no control over anything other than yourself and your actions and what you choose to put and think about in here. If you can't control that, how much control do you have of your life? Come on, man. Take charge of your thinking. Right, let's move along. Right, we didn't get a chance to cover this last week. This is a good point. Thank you, Mr. C, for reminding us. We're going to talk about this now. Evening, gents. What's your take on this proposed Sam's Law that is based on apparent post-separation abuse being continued by way of complying with a court order? Actually, we touched on this lightly, I think.
We did touch on this lightly, and I meant to, and I'm going to apologise in advance to Cozy, because what I meant to do this week was get an update on it and see what was happening with it, because currently it is just a proposal that's kind of floating around in the wind, and there's not a great deal that's particularly specific on it, but the issue is. And you're right in, where are we? There we are. I'm looking at the wrong screen. The issue is you're right in what you say. It is, but your comment that's based on post-separation abuse being continued by way of complying with the court order. I'm sceptical about it. I've got to be honest. What the law should it come our way? And as I say, I will get an update before next week. I will make a note to myself as to what's happening with it. But what it essentially says is that that abuse continues. We were talking about it, I think, last week. Abuse continues within proceedings, and abuse continues post proceedings. And so the abuser, the perpetrator, uses the proceedings to continue to protract the abuse, and then beyond the proceedings, once they get the court order they want, they comply with the court order, but they comply with the court order so specifically that it actually lends itself to abuse. And let me explain that. So the court order says 2 o'clock every other Saturday, the child is going to go to a contact centre and they're going to meet the parent who's meeting them there. And then at 4 o'clock, that parent is going to leave, and the child is going to be collected 10 minutes later by the other parent. There we go. That's the scenario we're looking at. And within the court order, we've agreed as parents that we're going to use a parenting app just to communicate with each other. So at midday, the parent who is the abuser, potentially, let's say there is an abuser in this scenario. So at midday, the parent sends a text to the other parent to say, just reminding you today's contact day. I expect you to be at the contact center at 1:45. And at 12:30, I'm going to send you another text to say, I expect you to be at the contact center at 1:45. Oh, and bring his football. And then at 1 o'clock, I'm going to send you another one that says, oh, I expect you to be at 1:45. Bring his football. Oh, and also bring him a snack. And so you're using this contact because at face value, all you're doing is looking to ensure that your contact is taking place. But actually what you're doing is intimidating by keep sending these texts. So the issue, and as I say, I'm going to be incredibly vague on it because I will get an update this week. But the issue is that there is a concern that it is that the number of cases where abuse is continuing within proceedings and the number of cases that are returning to court where one party is accusing the other of having continued to abuse them as a result of the fact that the court has provided this framework in which they can do it, is increasing significantly.
Yeah, well, I think the problem with this is I can see how this could be used to beat the NRP again. So if things start going the NRP's way, this law could be another hurdle that could be used against, unfortunately, in most cases, the non-resident parent, 90% who happen to be fathers. And I think I know a lot of cases where as contact was progressed and as fathers started getting contact, more hurdles and barriers and mechanisms from the court machine we use to then trip father up along the way, along with some of the other trump cards. So let's get the full details on this. But
yeah, I've just made myself a note for next week.
It just feels like there's another hurdle that we're going to have to try and account for. As you're going through your proceedings, we're going to have to try and account for the fact that, again, but look, if you stick to the 10 commandments of family court, I said, I'm going to have to actually properly write these down in detail. We're going to have to make the ebook and get this out every week. Put a link in. We need to get on this now, yeah? Now, in the 10 commandments of family court, I have mentioned before, again, you do not, if you follow these commandments, like I said, you won't even get to this situation because no unnecessary communication or engagement. Bare minimum. That's it. You don't need to go back and forth, so you shouldn't be engaging. Minimal contact, let alone any eye contact, nothing. Just do your handovers. Secondly, do not engage. Remember, we do not negotiate with, we know, I'm not going to say the T word, but you know that old saying, we don't negotiate with, do not engage in conversation necessarily. And the point, and that's exactly, and again, you present your best self. You're always well-spoken. You don't act on emotion. You do not get triggered. By this stage, if you have contact, number one right here, and you're communicating with your ex, that means via this app or whatever means of communication you have, means you are effectively co-parenting on some degree. Occasionally, I don't know, maybe both you might try and trip each other up. But the thing is, as a father, as someone who's fought for contact, you do not have time and the luxury of playing these stupid games. This is my point. You should not be engaging in these stupid games. In fact, I've said to fathers, you should be letting her believe she's got the upper hand on you. You need to make the opposition feel they are in control and they have the upper hand. So even when things are going really smoothly and you think you're gaining ground and you've got the upper hand, I would concede power. I would demonstrate and do something to show the other person or make them think at least that they are in control, they have power. Because remember, when you're dealing with narcissists, they need control. If they feel they have control, there's less chance of them putting hurdles and barriers up. This is my point. And in order to do that, you have to put your ego aside. You have to go along and play the good little ex-boyfriend, ex-husband, baby father, whatever you want to call it, and you play your role. Because the key is you're there for your kid. I mean, look, I just want to touch on this again, yeah? You know this chap, Mr. You know this fella, Dan, right? Yeah, we looked after him, yeah?
Mm.
Now, I was guiding him through all of his contact, his pickups and drop-offs. I told him, and it was working so well because she felt in control and power. But, and that's my point. And this is exactly what happened. Along the way, because he realized that because he was winning, right? Because he was getting what he wanted, but making her believe she's in control and power, he started getting cocky. He started doing things to get cocky. Now, my point is this: along the way, somewhere where the importance and the priority was spending time with his child, the opportunity presented himself again, emotional reaction, egotistical reaction to get one over the ex. And eventually he got cockier and cockier. When you start feeding the ego grows. And then what happens is, like I said, privilege is invisible to those who have it. Now, the fact that he had contact with his kid, he hadn't gone within one or two court appearances. He was playing the game until she pulled the rug from under, lost contact, got arrested, all sorts of allegations. Then suddenly reality hit him. But that privilege that he had at that time, when he was playing the game, he didn't see it. Privilege is invisible to those who have it, and then he had the luxury of getting one over. Eyes on the prize, emotional control, no unnecessary engagement. Do not engage in stupidity. This is about your child first. It's not about getting one over her. And this is what I'm saying. You have the ability to look in the mirror, truly look at yourself, yeah, and to recognize your own ego is very difficult. Your ego will put smoke and mirrors. You won't see it necessarily. You'll think I'm doing it for the kid, but is it really, or is it for you? Are you trying to get one over? This is what I'm saying. If you've been through all this trauma and pain and your ego has not been stripped away from you, it's not come to the surface, you don't recognize these things still about yourself, there's something wrong. I think there's something seriously wrong. You shouldn't even be getting into these things. Anyway, enough said. Let's move along. Right, Mr. S, the court released a court order when the deadline is already passed. I'm presuming dateline or deadline. So the court released a court order where the deadline is already passed. Dateline is already passed. Is it reasonable to write to court as the email is known? I presume it would be. But...
Where are we? Currently order date when the dateline's already passed. Is it reasonable to write to the court as the email? Yep, absolutely. It's absolutely reasonable to write to them and say, thanks for that, but unfortunately that's gone now, so you need to realign that. Yes, absolutely.
Yeah, it's just like my court order that went missing for 2 years, but yeah.
Indeed, yeah.
Yeah,
indeed.
Got an order once the non-more ran out. Yeah, great. Right. Mr. A, I requested a SAR from my counsel. It shows there is no evidence of financial control. Can I use this to dismiss her allegations? Also, mother is spent child benefit on her makeup. How would this look? Bloody hell. Okay, I suppose, look, that SAR can be used to demonstrate, to dismiss an allegation. I don't see why not. Bringing up the child benefit and the makeup, I don't know. I'm not too sure myself, but go on.
Right, let's have a look. So you've requested a subject access request from the council. It shows there's no evidence of financial control. Can you use this to dismiss? Yeah, you can certainly submit a subject access request as part of your case. You're entitled to do that because it's an independent document. So next time you have opportunity to submit, then absolutely submit it because it will carry some weight. Will it carry sufficient weight in order to dismiss our allegations? That I can't say without really understanding the circumstances of your case. Also, the mother is spending child benefit on makeup. How would this look? Well, we surmise that she would look lovely because she's spending the child benefit on makeup. So well done, mum, is what I say there. But no, I mean, realistically, the court, I'm resisting the temptation to say the court has better things to think about, but it does. People who go into court and say, "Ah, yeah, but mother's getting benefits and she's not spending it on the kids; she's spending it on herself." Blah blah blah. The court is kind of mute on that point because otherwise it would be there all day arguing why it is that you had an extra iced frappe in Starbucks, instead of putting new shoes on the kids' feet. That's not really their concern. That's a social services issue if you believe that those children are being neglected as a result of the fact that that mother is treating herself to Maybelline. It's not going to have any relevance. But the subject access in terms of demonstrating the financial control issue, yeah, absolutely use it.
Plus, judge might look like he's being petty with the old makeup stuff. I think it might just don't get reduced to the tit for tat. That's the point. Don't get drawn into it. This is what I'm saying. Yes, it hurts. It's not nice. It stings. I agree. But this is what I'm saying. Emotional control, eyes on the prize. Look at the bigger picture. We've got to forget all this little tit for tat. Yeah. We're there for our kids. We need to get access to our kids. So focus on that. Right, Mr. K. My ex selectively responds to messages that only benefit her. We have a court order in place. However, all conditions are ignored. How much is it a grey area to discuss contact with my daughter during video call? I'm being denied contact and access to spending time with my daughter. There are no explanations for why I can't travel. Now, if I remember correctly, his missus is in Poland and he's got a very difficult situation on his hand. Kashi, clearly, we read your comments every week. You are clearly in a lot of pain, going through a very difficult time. But yeah, just keep chipping away, keep your head up, just do what you can. You can only do what you can do and just do your best. Do your best, show up for contact, just keep showing up, hold it together. And Mr. Ryan, anything you could add to this?
Yeah, unfortunately,
Difficult.
because of I'm incredibly sensitive to Cash's issue because it is a challenging one, and because of the international element, that just adds the weight of the world to it. It really does. If this was a UK to UK issue, we could rattle it pretty quickly. It's not. It has an international element. It involves the Polish family court system, or it's going to involve the Polish family court system. It's going to be a difficult one. And the fact that, unfortunately, because the child is 1,000 miles away, or whatever the distance is between where we are sat and Poland, your ability to influence them joining you on a video call is nil. In real terms, it's nil. You are entirely in the gift of the mother who has the child for her to engage the call and allow you to have a conversation. Difficult, very difficult. Unfortunately, we are undoubtedly, if you're not there already, we are heading towards legals.
Yeah, Cassie, I would say try and focus on yourself, focus on your health, focus on, I would say the surrender tactic may have to come into play because as long as you show up for these video calls, as long as mum knows she has leverage over you, she will make you suffer. Sometimes you got to just sort of show that you're distant and you're okay and you don't care. And there's no fun for mother anymore, unfortunately. So maybe you might want to deploy the surrender tactic. Say, okay, I've done my bit. Good luck to you and the kids. I'll sit back and wait for you and them now. Over to you. Sometimes it's worked in a few cases that we've dealt with, so you may have to deploy that, Kashi. Right, Mr. C to Mr. J. Do the best you can to relax and switch off. During proceedings, as worse as things can get made up to steer the direction. Post final order, things can often get easier. I agree. Look, things can get easier. It's just, like I said, you need to get from A to Z. So many hurdles in place. There's going to be ups and downs, peaks and troughs, good times and bad times. Days where, listen, you're going to cry, you're going to throw up, you're going to be sick, you're going to miss your kids, but you're going to get to Z as long as you keep going. So throughout all of these issues, throughout all of these peaks and troughs, highs and lows, you're being tested. Your character's being pulled and stretched, your personality, your mind, your emotional capability is being stretched. The key is, the prize is your children, the bond and contact with your children. All you got to do is hold it together, keep chipping away, and keep moving forward. One step at a time, whatever you can muster. Just don't give up. Yeah, and just hold on to that little bit of light at the end of the tunnel, that little bit of hope, and visualize those days, those good days ahead. Visualize them. Think about them. Think about what you're gonna. I would start journaling as what you're gonna do with your children. What have you thought about? What are you gonna talk about? Where you're gonna go? What ice cream you're gonna eat? What flavor? Is it gonna have a flake? Is it gonna have? What do they put in ice cream these days? The ice cream van, whatever it is, those things they put
What,
on.
in London?
Yeah, well, wherever ice cream vans, the
Crack
ice cream van.
cocaine.
Listen, listen, listen. What?
Amphette.
Ketamine, yeah,
Spice.
ketamine, yeah. No, London ain't like that. Like I said, London's cool. London, it's the uncivilized up north, mate. That's where they got these problems. Crack fiends, all these crack fiends, and what they call skagheads, crackheads. It's up north, mate. These are all northern terms. Skaghead, scally, they're all northern terms. Remember that. But yes, going back to my point, getting back to the kids before Mr. Ryan just threw that sort of curveball in there. Start journaling the things that you're gonna do, where you're gonna go, what you're gonna eat, how you're gonna play. Do all that. Think about that. Think about the positivity. Right, let's move along. We're on a bit of a roll here. Let's move along. Mr. S. If someone has, who is this man? Sorry, someone keeps messaging me. Apologies, guys. If someone has a King's Council, what would be the first to go, or the applicant is first to go as a lip or with a barrister? I suppose a
Right.
barrister would go first, then, innit? As you mentioned earlier.
Well, the theory is, yeah, the representative for the applicant should go first. So whoever, if the applicant's got a barrister, then the barrister should go for the applicant should go first. But let me say this. If in the room there is a King's Counsel, and for those who don't know, King's Counsel, also often referred to as a silk, is the most senior rank you can get in the world of barrister. King's Counsels tend not to grace family court because it's a bit below them. They tend to work high courts, criminal courts, high-end civil court for big company trials where they can earn tens of thousands of pounds in fees. But having said all that, I'm now about to say that there is actually a bit of an increase in KC's, King's Counsel, turning up in family court. And I have to say, I'm a little bit worried by that, because that makes the whole top of this show argument about two-tier justice even worse. If somebody is turning up with a King's Counsel, the comparison I would draw, and I drew this comparison recently in a hearing, King's Counsel on one side of the room is Cristiano Ronaldo. The barrister on the other side of the room plays for a Sunday League team. That can be the difference. That is how stark. That is how stark the difference can be. And so, if there's a King's Counsel in the room, it's not unusual for every other barrister who might be in the room to bow down to the King's Counsel and let the King's Counsel go first, because they just want the joy of watching them work. And I appreciate that, because watching a decent King's Counsel in action is an art. Their grasp of the law, their grasp of the language is just beautiful. It's almost poetic. That's why they charge thousands, and in some instances tens of thousands of pounds a day to get them to come and play for you. But yeah, so often there can be a bit of, what's the word? There can be a bit of sort of professional admiration from barristers if there's a King's Counsel in the room, and they will often stand down and let the KC lead the show.
Okay, stop. I'm sorry, I might have missed the first bit, and I apologise. So, the King's Counsel is like a barrister, but it's like top end, like I say, it's Ronaldo or Messi.
Top end, most, yeah.
Walk in of the barrister world. Clearly, everyone's going to bow down to his superiority and skill set and articulate or oral abilities, orating abilities to just say, right, let him go, because he's obviously the big cheese in the room. That's what it is.
Yep.
And that, again, let me clarify: can money buy a KC?
KC, it needs money. Nothing else buys a KC.
Oh, okay, fair enough.
If your average barrister, if your average barrister in family court's about £3,000 for a hearing, ish, that's about the average price. A King's Counsel, double it, treble it.
See, bottom line is this right here. My theory in itself is correct. The theory and the understanding I have of money now is correct. money can give you money can remove many problems out of your life. That's a fact.
Mm.
And people say, these negative connotations with money is poor people language. Oh, money don't buy happiness. Listen, money can buy you goods and services. Money can eliminate, I would say, 80% of the issues that the normal working man would face as a normal working person. Money can eliminate most of these issues. See, I look at my situation now. If I had like KC type of money, like serious money, yeah, I'm not talking like, just a working man who's got a bit. I'm talking about serious money, disposable income. Like I said, what? Yeah, Dan, just get a KC. I don't care. Just get a KC. 30 grand. Who gives a shit? Just it's an open checkbook. Just do what you got to do. I am sure we'd have got, be a little bit further ahead than where we are now. I'd have got one hearing at least. I'm sure I would have got one child access hearing. Like, it would have just taken off the ground at least.
You would indeed. You would
But
indeed.
I sometimes think, right, the fact that we sit here and we laugh about this, the fact that my case didn't even really get off the ground, right? It's a miracle, really, that I can even laugh about this.
Yes. No, I admire your resilience, Joe. On we go.
Mr. A, if I change my solicitors and use a Mackenzie, do you have barristers who can filibust? Right, Mr. Amp, I don't know if you're aware, but there's a lot of guys that get in touch with me, that email me. They say, hook me up with Dan. Is Dan any good? I say, listen, the man is right here in front of you. You see him week after week. I'm not here to sell anything to anyone. Do you know what? To be fair, let me put this out there. In 52 streams, we have very rarely tried to sell anyone anything. I want this to be pointed out, because on the internet, everyone's selling something, yeah? We have literally just been here providing information and knowledge, and people have had solicitors and barristers. We've not even said, come over to us, nothing like that. But I'm going to say it today, Mr. A. If you're using solicitors and spending that money, right, yeah, I would say save your money. Number one, I know we said money's a leverage, but my point is you use the leverage where it's most effective. Let's put it this way. Now, we have solicitors on board. We have barristers. We have firepower, but we bring it when it's most effective. We don't just fire empties and blanks and just waste our bullets, yeah? And solicitors, mate, they don't care. It's just you're on a retainer. In a retainer, every 15 minutes, bam, mate, that's it. Number 200 quid, number 300 quid, boom, boom, boom. We use your money as leverage where it's most effective. So I would say, Mr. A, I am saying it now, get over to Mr. Ryan, arrange a call, let's do a case review, and let's get you on board. Let's get the winning team behind you. Get on board. We'll save a bit of money. We're there for the result. We want the results. We will tell you, you bring in the barristers to do the filibust when it's most effective. So yes, what are you still doing with your solicitors? I can't even believe you're asking this question. Get over to the winning team. Family court mastery. Let's do it. Right, Mr. S, can a FF go ahead without police disclosure? That's a good question, actually. I'm curious.
Yeah, can a fact find go ahead without a police disclosure? It can, actually. If the court has ordered a police disclosure and it hasn't turned up for whatever reason, the court can take the proportionate decision that rather than delay any further, they're just going to push on without it. And they'll just rely upon the evidence that's in front of them in order to make the decisions they want to make. So yes, yeah, they can.
All right, Mr. A follows up with more detail. Can FF go ahead without police disclosure and statement of allegations? Can a hearing be cancelled if this is not received in the next 6 weeks? So without the statement of allegations, I suppose it will be a bit difficult to...
It would be a little more difficult then, because we don't know what we're going to argue about. So yes, so if there's been no schedule of allegations has been submitted, then the fact find is going to be ineffective and is going to fail.
Yes.
So whichever side is waiting for that schedule should be alerting the court at this stage to the fact that they haven't had it, in order to give the court opportunity to either move the fact find or indeed cancel it.
Perfect. Right. I want to take this opportunity to say, guys, please hit the like button, like, subscribe, follow, and share. Get the link for this channel out to those who may need it. We try and just provide help and support, putting value out there and positivity into the universe, giving people hope. That's why we're here. We're bringing hope. So look, press the like button. That's the least you can do. And also, I forgot, I have not mentioned this in a long time. There is a PayPal link in the description if you want to help support the channel. Make a donation. PayPal link in the description. And it wouldn't hurt any of you to drop in the odd super chat. Actually, you've noticed I'm not in my studio. I'm sitting in this little hut. Yeah, luckily it's got aircon. I was going to say it's really hot. It's not. It's got aircon, so it's all good. Yeah. And the reality of family court, guys, I know I look great. I know I look like a superstar, but I assure you, I ain't got superstar money. I'm hustling just to get by, as per usual. So the odd super chat wouldn't go amiss. Do you know what I mean? Right, here we go. Right, Mr. H, I've watched the podcast. That's how I met him. He actually guided me to legal aid and helped me loads. This is the fella that's been sentenced a week. In the podcast, he did not say any names, locations, or details. No, Harry. Sorry, not Harry. We're not going to mention any names. No, Mr. H. The key is it's not the fact that he didn't mention locations or details. Now, he must have said it's either the manner he presented it in, or he must have said, I tell you what, send me the link. WhatsApp me the link for this podcast, and I'll send it to Mr. Ryan. We'll both watch it and we'll see. What we might do is we might do, depending on how long this podcast is, we'll watch it, we'll pick out segments, and we'll do a live watch along, and we'll do a live breakdown and say, guys, this is where he went wrong. He shouldn't have said this. Or if you're on a podcast or you're talking about your case publicly on social media, let's do a stream actually on social media do's and don'ts when you're going through family court. Yeah. Okay, we'll do that in the next 2 or 3 weeks or something. In the next 2 or 3 streams, the do's and don'ts of social media and podcasting if you are going through family court. So yes, and send me the link, Mr. H. We'll do a little live breakdown of it. Right, Mr. J. Hi guys, thanks for the stream. You're welcome. Could you give a quick bit of advice on disclosure? Can you ask for WhatsApp messages between mum and a third party like maternal uncle? Okay, that's a good question. That's an interesting
You can ask.
question.
You can ask for anything. You can ask for anything you like. Whether you'll get it is another thing entirely. The court, if the court is asked to rule on it, their issue is going to be, why do you want this information? What is the relevance of it? What is it that you're trying to achieve by providing it? Because the issue they're going to have is that there is a third party involved, which is in your case, the maternal uncle, which means there's a GDPR issue, there's a data protection issue of involving a third party and involving their material that they've provided. But if you have a good grounds for wanting the disclosure because you believe it's going to show you A, B, or C, then make that argument to the court.
Right. Okay. Perfect. Before I carry on, I've got a message from one of our regular viewers. He said, "What's the outcome of your case if it's now finished?" Now, if you remember, I actually talked about my case, I think 4 or 5 or maybe 8 streams ago. I can't remember. It must have been a couple of months ago. It was a while back now. By chance, basically we tried to force a bit of action to the court to see what the hell's going on, because as you know, my case has been sort of in limbo ineffectively for 3 years. It turns out, along with when the non-mol and the occupation order was discharged, which was in limbo for 2 years, I just want to highlight that was a disaster in itself. The child access again was a separate case on top of the non-mol and the occupation order, but along with the court orders from the occupation order and the non-mol, which we were still waiting to receive, someone in the East London court, unfortunately, just by randomly just shut everything down, said, "Oh, here's a court order. This case is finished," and just randomly just close everything. It's just a very bizarre situation. So we are now seeking to go back, try and reopen it, highlight the incompetence, and in the meantime, some other things have happened as well. But look, I'm cool, guys. I'm cool. It's meant to be. I told you. You know, you guys should look at me. I haven't seen or spoken to my children in 3 years. My case is nor here nor there. Do I even look upset? Do I look bothered? Do I even look remotely worried to you? I lived in limbo for 2 years at the back of a van. Didn't do nothing crazy. I've lived it. I walked it. So when we talk about patience, I'm living it. I'm living it every day. And I'm still telling you, on the back of all of this, I'm telling you, I'm going to be resident parent at some point. I'm going to have full custody. We're going to be doing a stream one night, and my kids are going to be coming across here, hugging me, saying, "I'm saying good night, now go to bed. Daddy's doing his live stream. Go away. Boom. I'll be doing that live at some point. It's going to happen.
Ever the good parent.
Stop
bothering Daddy.
Quick hug. I'm on a live stream now. Come on, get off me now. Go. Actually, before you go bed, make Daddy a hot chocolate. Come on, boom.
Yes.
Done. Now look, it's going to happen, guys. You've got to believe in it. You've got to know. I know things. I mean, I'm doing stuff. I know things. It's going to happen. Right, let's move along. Also, from Mr. J, did you see the Women's Aid report this week? Oh, you have to drag the conversation down in and mention the WA. How could you mention WA? That's a swear word right here.
Yeah, bless them. But to answer the question very quickly, yes, I did. I think it was Tuesday or Wednesday it came out. And the only interesting thing in it, to be fair, and this is just my opinion, I don't mean to demean them, but the only thing interesting in it was that they have recorded their highest number of contacts in their 50-year history for the number of people contacting them to report domestic abuse. That's at face value, that's incredibly sad, because that is a reflection on our society. If we dig into the detail of that also, you know my view on false allegations of domestic abuse from either party. Let's be equitable about this. But yeah, that is incredibly sad that if that is the case, that we are as a society either experiencing greater levels of domestic abuse or experiencing greater levels of false allegations in order to win a position. Either way, not a great place to be.
I think it's worse than that. I think the problem is, I think the overall issue is, like, see, when you talk about society, is what relationships are. What is now classed as abuse in a relationship? What was deemed as, say, for argument's sake, deemed as something normal in a relationship is now deemed as abuse. Like I said, a basic conversation about finances is called financial abuse. So either, like I said, society has got to such a point where, I tell you what it is. It's the battle of the sexes and the gender wars just slightly going out of control and crazy. And society, the biggest divide in society is male and female. They are it's the battle of the sexes. It's just playing out. And now it's in every facet of the law, especially within family law, women's aid, all of this. And it is sad. Look, I hate to say it. I agree with you. I think it's just very sad that we are in this situation. But look, don't focus on the negative. Let's try and stay positive. Focus on you, because the only thing you can control is what you do, your actions, and what you think about. Right, Mr. D, think you know me? I mean, are you asking me? Like,
do you know him? He's been on before. Bless him.
Okay, so all right, the answer is yes. We think we know you. I recognize the name. I've definitely seen your name before. My ex spent 50K on a barrister solicitor. July 16th, phone call, Zoom, court date, August in court. Okay, so he's followed up with,
there we go.
What will a Zoom call be about before final day in court?
The Zoom call, I presume, and we can make this incredibly quick, I think the Zoom call is probably going to be what we call either directions or a PTR, pre-trial review. And it's really just setting up for the final hearing to make sure that we've got all the statements that we want, to make sure that if we're pulling witnesses in, that we've made those witnesses available. We've decided which order people are going to be cross-examined in. If Kafka's going to be in the room, if social services are going to be in the room. So it's just a little half-hour, 1 hour hearing, just to make sure that when the final hearing opens up, we're not messing about at the start of it.
Okay, perfect. Mr. S, if the legal rep I had did not seek my input when the judge asked on email and a decision was made, can I write to the judge? Can I write to the judge to show prejudice?
So if your legal rep, let me just make sure I understand this question. So your legal rep, are you saying that your legal rep made a decision in the court on your behalf without consulting you? Is that what we're saying? Just give me a yes or a no on that.
Let me see. All right, he's got a follow-up, but let him come back with an answer. His follow-up in the meantime, what happens if disclosure comes up later? This is another guy saying. What
Yeah.
happens if the disclosure comes up later after the fact find?
So if a police disclosure will eventually appear. Sometimes they take forever, but they will eventually appear. But if the court has made the decision not to wait and to go ahead with the fact find, they will complete the fact find, and then as and when the police disclosure arrives, all parties will be given the opportunity to consider it, and all parties will be given the opportunity to opinionate on it. And it may or may not have some bearing on what has happened in the fact find.
Fair enough. Right, Mr. C. Dan, this is a good question. Can you speak a bit about GDPR and kids' Medi records and how you approach a doctor's? What does it look like in practice? Do you contact them periodically? Ask to be informed when appointment made. This is a good question.
It is a good question, yeah, because this is an issue that happens time and time again for the non-resident parent, regardless whether it's mum or dad, is that you contact the doctors where the children are and you say, hi, can you just give me an update of the children? And they go, no, because the other parent has closed the door on you. It is very difficult because even though you can remind the doctor that the children are registered with, that you do have parental responsibility, you are legally entitled to have access to those children's records. They will often be very resistant. And in my experience, and I've tackled this issue a number of times over the years, remind them in email if they are being difficult. Let's start with that. If they're being difficult, remind them in email that you do have full parental responsibility. You are named on the birth certificate, or you are the birth mother. There's the first stance, and you are legally entitled to access to the medical records. If you are still getting reluctance and resistance, at that point, I would write to the trust, the NHS trust that GP's practice is affiliated to, and just complain bitterly to them. And usually that will work and you'll get the records that you want. So that deals with that whole issue of resistance. They will offer the GDPR questions. So they will say, oh, well, we can't tell you it's data protection. Your stance is, I'm the parent. Data protection doesn't count for me because I am the parent and I'm telling you I want those medical records. Be blunt with people. If you've got to be blunt and be rude, be blunt and be rude. If that's how society has made us, go for it. Yeah. So start by being very reasonable in your approach. Hello, I'm dad, I'm mum. I'd like access to my children's records. Can you send them to me? And if there's a cost, can you indicate what that cost is? There might be a small charge for the printing or whatever. If they come back and tell you it's £1,000, then tell them that you'll contact the trust and get it via them. You should be contacting your children's doctors if you're not getting information from the other party, from the mother or father who the children are with. You should be contacting your children's doctors probably every 3 months. I don't think that's disproportionate. More often than that, it's perhaps a little too much, and perhaps a little bit stalkerish. Every 3 months, just contact the doctor and say, can you just give me an update on the medical records? I've had up to April, for argument's sake. I've had up to April 25. If you can just give me anything from April 25 to the current, just so I can keep them up to date. They should have absolutely no issue with that. In terms of asking them to inform you when an appointment is made, you're entitled to ask, but I'll be perfectly honest, having had a reasonable engagement with doctors' practices over the years, that's quite a task for them, because that's just adding to their workload, that they're having to phone you to say, look, just letting you know that your lad's coming in this afternoon or tomorrow. I am probably on the side of the GP if they say, no, we can't do that. That's just a bit too much for us to do. And I don't think that's unreasonable of them to take that stance.
Okay. I think that answers the question in great detail. Right, Mr. H, I will try look for it or ask him when he contacts me. But from what I know, he had to get it taken down. Yeah, the chances are the judge will order it to be taken down. Just so your message, it's on the Baby Fathers podcast. I'll have a look when I get a chance, see if that episode's there. But just to put it out there, I've been on the Baby Fathers podcast. Look me up on there, type my name in, Baby Fathers, Farouk, or Baby Fathers, Disqualified Dads, or whatever. Yeah, you'll see my face on there. Check me out. Go and watch that episode. Been there. Right, Mr. B. Be inspired and inspire. I like that. Hi, I had my final enforcement hearing. 2 boys, 15 and 11. Kafka said boys want contact, but recommend it is left to them to decide rather than prescribe, as was ordered in final hearing in 2024. Judge followed through the recommendations from CAFCAS that the 15-year-old cannot be forced and the 11-year-old won't come without the 15-year-old. Judge ordered this. I have the X107 appeal form. I don't want my 15-year-old to control my relationship with my 11-year-old. I want prescribed order, contact independent of him. What are the chances of success in an appeal? All right, this is a good question.
Okay, and this isn't, I'm not, my next response is not designed to be blunt or to crush you or any way whatsoever, but I'm going to be very blunt with you. You will not succeed in that appeal. In fact, you will be declined permission to even make that appeal. And I will tell you why. Your two children are 15 years old and 11 years old. The view of the court is once a child gets beyond 14 or 15 years old, they will vote with their feet. And that is a phrase that the court uses time and time and time again, which means it doesn't matter if you tell that child that every Saturday they've got to report to the local church and talk to the vicar. At 15-year-old, they're not going to do it unless they want to. And your problem is that siblings influence each other. And so we all look to our older siblings to get our steer. And so the court's view that your 11-year-old will walk in the shadow of your 15-year-old is probably a not unreasonable stance to take. And so I appreciate your frustration. I appreciate the fact that you want the court to order that your 11-year-old will do A, B, and C. But the reality is, I think they were boys. The reality is, he won't. He will follow his older brother. And if his older brother is positive with you, and obviously we don't know what the dynamic is, but if his older brother is positive with you and wants time with you, then the younger one will come too. But if the older one is saying, no, I don't want it for whatever reason, then unfortunately you may well find this, the same brush is tarring the younger one. Okay, so we're just going to get an update. So you have appealed, and the court has asked you to request a transcript. Okay, so hence the EX107, and it's now gone to an HHJ. Okay, so let's carry this on. So the way, because we're now getting into the realms of appeal. So the way appeal works is that if you want to make an appeal to a judge about a decision made by a judge, you cannot appeal a decision just because you don't like it. Your only basis or grounds for appeal is that the judge has erred in law. The judge has made a mistake in the application of law. So the appeal that you're making, you have put your skeleton argument forward, you have put your application forward, and you've now been asked to provide a transcript. The reason you're being asked to provide a transcript is because the judge who is going to look at your application wants to see what was said during the hearing. Transcript, hence the reason that earlier on this gentleman referenced an EX107, which is the application form for a transcript. A transcript is a written copy of everything that was said in the hearing and who said it. That's what it is. They can be incredibly expensive. But anyway, so the judge, as a minimum in an appeal application, requires the transcript. But unfortunately, having said all that, I stand by my original comment. I think it is highly unlikely that a judge will allow permission for you to go ahead with for your appeal to be heard, because I think their view will be your 11-year-old, by the time we run this appeal, will probably be much closer to 12. If we then decide that your appeal is successful, and let's go with that for a minute, well, that means that all you're asking us to do then is return the matter to court and find a new final hearing and find new directions against your lad. By that point, he's over 12. He's heading towards 13. The court's back with the 15-year-old problem again, isn't it? About voting with his feet. I think that's how it's going to run. I would love to be wrong, and do keep us advised, but I fear that's where it's headed.
All right, let's move on. Right, I'm just conscious of the time. I'm going to start flying through some of these now. Yeah, let's really fly through now. Yeah, right. Go on.
Very quickly before we drop into Lou, let's just cut back to S, who obviously was asking us the question about the fact that his barrister had made a decision without consulting him, and he's come back to say that is a confirmation of what of what was done. He said he didn't seek S's input.
Right, there you go. I found it. Yes.
Yeah. So very simply, if you've got a court order in front of you that you don't like, because your view is that you were not consulted, you are in the realms of appeal. Hence the reason I've just tagged it into the conversation we were just having. You are in the realms of appeal to try and appeal that court order and say that essentially your professional was not acting on your direction. and then the court will need the transcript in order to look to see whether there was any conversation betwixt you and your professional prior to decisions being made. And they will also look at the decision that has been made that you do not like and the weight of that decision in the overall proceedings to decide whether they want to pursue an appeal or not. That's why I've dragged S in. Right, back in.
Right, perfect. Right, let's start flying from Mr. Lewis Hendrickson.
Yes, where's Lewis? Yes.
Mr. L. My barrister mentioned that the court can order unpaid work for the resident mother. Is this true if she defies the court orders?
The court, in terms of the defying of court orders, the court has a number of instruments available to it. One of those is a fine, is a financial fine. One of those, or unpaid work. Another one is the seizing of assets, and then the third one is sending them to prison. And we keep coming back to prison. I don't know why, but in the almost 20 years that I've been doing this, I've only ever heard of 2 or 3 occasions where somebody's gone to prison. It has always been for little more than a day or two, really, just to give them a bit of a shock, or a couple of hours in the custody suite downstairs. So that very rarely happens. Does a court indicate unpaid work? The circumstances need to be pretty extreme. Courts do not act on penal orders and hand out punitive measures very often.
Right, okay, let's move along. Right, comment from Mr. C. There's only one way. Remove the man, remove the problem. Joseph Stalin. And also, £20 super stat from Mr. C. Thank you, Mr. Cossack.
We've swept past Joseph Stalin. We've swept past Joseph Stalin and his influence upon the Russian history of the turn of the century, or turn of the last century, and we've moved on to your super chat.
Yeah, listen, that's dinner. That's dinner right there. I'm not going to starve tonight, boys. Thank you, Cossack. Now let's go back to Joseph Stalin. You are a educated man, Mr. Rice. Let's talk about this for a second.
Well, actually, when it comes to Russian history, I'm a relatively educated man. I did a bit of Russian history back in the day when I was still studying stuff. So yeah, I do know a bit about the good gentleman, Mr. Stalin. He was a fun character, but we'll save the history lesson for another day. But the point he's making, remove the man, remove the problem. Stalin was of a view that it was sort of a pre-union issue. Stalin was of a view that if you have a problem in the workforce, and it was mainly about the workforce, if you have a problem within your workforce, you find out who is the problem and remove them. You don't you don't have to resolve the problem, so that you find the problem.
I can comment on this, right? Working in the engineering industry, maintenance industry, I've worked in the rail underground, or I've been a member of the RMT. When I was an apprentice 25 years ago, the guy I was working was 6. He was 60. He was young. He was a young man working in the trade back in the 70s and 80s and 60s when, the name's gone now, where there's, the labor strikes and all that used to happen, right? Yeah. So I'm well familiar, and I'm well familiar, the guy that works in construction on the tools and in maintenance, like I said, you get a lot of these anti-establishment, anti-management, anti-government types now, yeah? And in a lot of these cases, Stalin might be right, because in a lot of these cases, I was actually the problem. I was the problem in some of these cases. But like, I was too good. They couldn't catch me. They couldn't pin me down, slip and slide. I know when to play. I know when to fight, yeah? So they couldn't catch me. But I have to say, in all of these environments that I've been, like I said, look, I've dealt with hairy-ass tradesmen and engineers now. Yeah? These guys, they moan. And most of these guys, I hate to say it, the environment in maintenance and industry, I feel sorry for apprentices these days. There is a very negative environment, negative attitudes. There's guys that moan from 8 in the morning to 5 in the day, moan about everything. If you come to work and they gave you a gold bar in one hand, they will moan about how they only got 1 gold bar and not 2. Like this is the level of petty, like, type of moaning we get now. And with a lot of these characters, there is generally one person, a dominant character, who can plant these little seeds. And most people, I hate to say it, most people are just followers. Even those guys that you think, I've got my opinion, listen, they are followers to the dominant character. So you know what? Actually, Stalin, I'm with you on that. I agree. And along the road, along my journey in maintenance, I've collected a few heads myself. I've removed a few men myself. Don't worry about that. So yes, that works. Right. Here we go. Sorry, what did I do there? Right, from Mr. B again. It is a disgrace. 15-year-old controls my contact with my 11-year-old.
It's let's correct.
11-year-old.
Let me set you back on a different path. It's not that the court is saying that your 15-year-old controls the contact with your 11-year-old. Because that's out of the court's control. What the court is saying is it is being realistic. It is being realistic about how siblings relate to each other. And obviously, I've worked with children for a long time, indirectly through family court. But I also have a lot of direct engagement with children for various reasons. Siblings do follow each other, and the court is just alive to that fact. And so whilst I'm equally disappointed that they might not have put some sort of framework in place for your 11-year-old, I think whoever you were in front of on that day was pretty pragmatic and said, look, the reality is if I put in place that your 11-year-old has got to do this every other day, blah, 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 it's highly likely that they're just going to ignore it because they're going to look to guidance from the 15-year-old in the same way that all of us look to the guidance when we were kids. All of us look to the guidance of our older brother. Of whatever he did, I did. Whatever he did, it was the right thing to do. I've got an older brother and he's a fabulous human being. But I look to him, on many occasions when we were kids, and sometimes that was not the greatest thing to do. In fact, it was an act of stupidity. But we did, and so the court is just pragmatic to that situation and alive to that situation. So I understand your pain. I understand that your frustration, but it's not. I wouldn't describe it as a disgrace. I think it's just a court being real.
Yeah, I would say, look, carry on with your appeal, see how far you get. Hopefully you will prove us wrong. Look, you just never know. My policy is this: go with the appeal, chip away at it. If you're not happy, chip away. At least you know you tried, you left it all in the ring. Yeah. So be inspired and do it. Take action. I'm a big believer: action, outcome, results. Yeah. So, and he who dares wins. If you don't roll the dice, you will never know. So I hope you prove us wrong. I hope you prove Mr. Ryan wrong. We hope you get a better outcome, yeah? So chip away, give it your best. And secondly, I would say, I'm presuming your relationship with the 15-year-old ain't great, and he's obviously the 11-year-old's following the 15-year-old, and you're relying on him. Maybe just try and work on that. Maybe try and get him on board. Do what you can. We don't know what the relationship's like. Obviously, let us know. But work on that relationship. If you've got contact, try and build on that. Remain patient. It's not easy. It doesn't happen overnight sometimes, but just keep chipping away, yeah? And he's followed up with, thank you for your reply. What if there was more children? I just feel that elders have so much leverage. Well, look, I think Mr. Ryan's already sort of covered that. So just work on that relationship, chip away at it, and remain positive. And yes, go for that appeal. Let us know how you get on. Right, we're going to make this the last question / comment of the night. It's been 1 hour, 22 minutes, as per usual. Mr. S, do you need to seek leave for appealing? Do you need to seek leave for appealing, or can you just appeal? When can you appeal without seeking leave? Right, I hope that makes.
Let's just clarify what seeking leave is all about for those who aren't familiar with that term. In court, if you don't like a decision and you want the opportunity to appeal, the formal procedure is on the day that decision is handed to you, you decide you don't like it and you seek leave to appeal. So you ask permission of the judge in front of you to say, Judge, with all due respect, I think you're wrong. I don't like what you've just ruled. I wish a permission to appeal. The judge then has to grant you that permission to appeal. Now, the reality is there is not a judge on the planet who is going to grant permission for you to appeal against a decision that they've just made, because by virtue of that, they're suggesting that their own work is wrong. So they will. It's very 99% of the time you will be declined permission to appeal, but you still. That doesn't mean you can't. It means you've done the first part, which is I've asked for permission. Permission has not been granted. I still have a right. You have a right under family law in order to appeal. So you can just crack on and do it. Given that you've only just received this order and a period of time is clearly passed, your bigger issue is not leave to appeal. Your bigger issue is being out of time, because there's also a time limit on making an appeal. So you are going to have to put together, apart from the issue of your appeal and what it is you don't like, you are also going to have to put together an out of time application to say, I know I'm out of time. I know this is later than it should be. This is the reason why I'm out of time, because I've only just got the information or whatever it might be. That's your bigger issue, is the out of time issue, rather than the leave to appeal.
Talking about out of time, it's been 1 hour.
Nice. I see what you've done there.
And 25 minutes. It's been bang on 1 hour and 25 minutes. This is the episode 52 on disqualified dads, along with that family law guy. I think this was a successful stream. I think we covered a lot of ground. And yeah, I enjoyed it, guys. I'm happy to be here, happy to be of service. Mr. Ryan, any closing comments?
No, well, close with those of you, as I do every week, those of you who are in court in the coming week, our thoughts are with you. Positive energy. Think about the children. Focus on the children. Focus on what it is you're trying to achieve, and let's not focus on the conflict with the other side, because that is just negative. Two-tier justice, my view. We do operate in a two-tier justice system. Not a great deal we can do about it, but at least we're alive to the fact. Have a good week, guys.
Yes, guys, say 3 words: patience, perseverance, and belief. Have a good week. Keep chipping away. Like, subscribe, follow, and share, and we will see you on the next one. And we are out in 5, 4,